This mini symposia focused on child access prevention laws and extreme risk protection orders, 2 laws to reduce firearm violence. I'm April Zeoli, Associate Professor at Michigan State University and FACTS Faculty Consortium member. The study of the implementation, use, and impacts of firearm laws is a very important piece of firearm violence research. These laws have the potential to affect all of us, and it's critical that we understand the nature of these effects. Today, we'll hear about child access prevention laws, which intend to keep children from gaining access to guns, and extreme risk protection orders, also called firearm restraining orders, which are a civil court order to temporarily prohibit a person at imminent risk of harming themselves or others from accessing a gun. At this time, I'd like to present our speakers. First, Dr. Elinore Kaufman, Assistant Professor of Surgery at the University of Pennsylvania, will present on child access protection laws as a means of preventing deaths from unintentional firearm injuries. Michele Grim, a recent graduate from the Doctor of Law and Policy program at Northeastern University, will discuss the implementation of Illinois' Firearm Restraining Order Act in the aftermath of the Parkland shooting, including barriers and facilitators to implementation. And finally, Jennifer Paruk, a doctoral candidate at the Michigan State School of Criminal Justice, will present about the reasons and risks motivating extreme risk protection order petitions in the state of Florida. After the presentations are complete, we'll have a Q&A session. If you would like to submit a question, please use the Q&A features located in your bottom menu. We encourage you to send in your questions before the end of the presentation so we can have a chance to review them. As a reminder, this session is being recorded. Only the presenters and moderators, me, are visible. Chat is disabled, so please use the Q&A feature for all questions. And if you would like to hide the captions, please click the up arrow next to your transcript button and then select Hide Transcript. At this time, Sonia, please share Dr. Kaufman's slides.
All right, thank you so much. I'm excited to be here virtually and to have this opportunity to discuss our work on child firearm deaths with you all. Next slide, please. And especially to be representing and be part of such an awesome research team led by Doug Wiebe and funded by one of the new sources of funding that we were hearing about this morning, the National Collaborative on Gun Violence Research. Next slide, please. So I'm going to be talking a bit about what we're hoping to do in general about our approach to variation in firearm deaths, and in particular about unintentional firearm deaths and firearm suicides among children. So for both of these types of injuries, the firearms involved tend to come from the child's home or the home of family or friends. There's good evidence that secure storage, such as that pictured here, so unloaded, locked, and separate from ammunition, can reduce risk of injury and death. But there's also good evidence that many children are around guns that are not secured. And actually, even when children have symptoms or histories that put them at higher risk for suicide, families do not automatically incorporate secure storage. So we know there's plenty of room for improvement here. Next slide, please. Child access protection or prevention laws are one policy option to try to prevent these injuries and deaths. There's no federal law, but 29 states and DC have laws that impose criminal liability related to child access. These laws vary extremely widely, with the most probably lenient applying only when a child actually accesses the firearm, shoots it, and causes an injury. One of the strictest laws would apply when a firearm is stored in such a way that a child reasonably could access and use it, even when that actually hasn't happened. And there are laws all across that spectrum. I would also say that these laws have the potential to appeal to a broad constituency. Many firearm regulations are focused in one way or another on reducing the overall firearm availability. CAP laws really are not. They're about securing the firearms you already have and protecting children. Evidence bears this out. About 80% of Americans support these laws. Next slide. So CAP laws certainly have the potential to promote secure storage, and they have shown a modest benefit for reducing suicides among older teens. This is compared to, for example, age restrictions by Webster et al., which are not necessarily effective as kids are generally accessing guns that are already in the home. Next slide. All right, so I apologize if this is hard to see, but we tried to summarize the wide variation in CAP laws into 2 categories: those that apply to storage, regardless of whether a child actually accesses the weapon, and those that only apply when the child actually does something. And so you can see these laws coming in primarily in the 1980s and early 1990s, but also as recently as up to 2012 in Oklahoma. Next slide, please. So to take a step back, the sort of general approach that we want to take to identifying key factors associated with firearm mortality is to identify states, counties, and population groups with outlying rates of death or change in deaths over time, and to focus on those outliers and kind of, in a data-driven, inductive way, identify features that might be associated with lower rates of death. Next slide. So our outcomes are counts and rates of firearm injury death in various categories that are drawn from the CDC, and these are the complete files from 1990 through 2017. The exposures of interest that I'm going to talk about today are primarily the CAP laws as well as urban versus rural geography, but may also include other policies, local demographics and socioeconomics, features of the built environment, access to trauma care, close to my own heart, law enforcement activities and characteristics, as well as community resources. Next slide, please. So I'm going to talk first about unintentional deaths. I skipped a bit. County level firearm deaths that we're looking at right here are in individuals 0 to 15 years old, so sort of our youngest kids. And we're looking at unintentional deaths and suicides with counts aggregated over 5-year periods. These are rare deaths, as you'll see in a second. So annual counts and rates become pretty challenging. All right, next slide. So the first thing to notice is that these deaths are rare at well under 1 per 100,000 per year in this age group. Only about 1% of unintentional firearm injuries end in death, so this is not so surprising. And there does seem to be a pretty encouraging trend at the national level, which is what we see here, with a steep decrease to a nice low plateau over the last 15 years or so. Now, there's a lot of factors that may be at play in this decrease, but certainly one factor that came in over this time frame is the CAP laws we're talking about. Next slide. So of course there is variation, and given the rarity, we aggregated the data into 5-year chunks, like I said, comparing the 5 most recent years of data to the 5 earliest. Nearly 2,300 counties had 0 deaths in both time periods, particularly in rural counties, as you can see here. Of the counties that did see deaths, the range of change was pretty wide, from a decrease of 19 deaths up to an increase of 4. Next slide, please. And we looked at a very simple negative binomial regression model adjusted for urban versus rural status and population. And we can see that storage-based laws had a small but significant association with reducing death rates. So that each year the law was in place was associated with about 2.6% fewer deaths when we look at that most recent 5-year time frame. Interestingly, the non-storage based laws, the laws that require actual action by the child, were not significant in this evaluation. And urban versus rural geography was highly significant, which is true in itself, but also likely indicates that there's many other important factors to be incorporated. Next slide, please. As I told you, we're hoping to spend some time looking at the outliers. So here are the 20 counties that saw the biggest decrease. And now this is a decrease in death counts, so we're seeing larger counties here as you would expect. In some sense, it's better to look at rates per population, but it's tricky with these small numbers because you have a county with a small population that has a single death and a very high rate per population, but not really a meaningful or reliable rate, so it gets a little tricky. Regardless, not all the large counties across the country are showing up, so there's more to learn for sure about the differences among places. Next slide, please. So this is an analogous look at suicide, but unfortunately the national pattern is not as good as I think many of you probably have seen in other age groups as well as in children, with rates continuing to rise since the mid-2000s. Next slide, please. So we see a similar pattern across the urban and rural geography, with nearly 2,000 counties with 0 deaths in both time periods, and a wider range in terms of decrease, with as many as 32 deaths and increases up to 11. Next slide, please. And this is that analogous simple regression model. We again see some benefit from the storage-based laws with 1.3% fewer deaths for each year the law was in place. And we don't see any effect, again, from the laws that only come into effect when the child actually accesses the firearm. We again see a major difference with urban counties having many fewer deaths proportionally. Next slide, please. So again, we're taking a look at the outliers here. It's a similar but not an identical list. Plenty more to understand about the differences among these locations. Next slide, please. So there's plenty of next steps ahead for this project, and what I've been showing you here is kind of just a way of thinking about things and some very preliminary results. So thank you for your patience with that. We are looking forward to digging in to investigate our outliers in much more detail, which should lead to incorporating other known and unknown factors. As a trauma surgeon, I deal with the living and I try to keep them that way. So I'm always looking for ways to gather and incorporate data on non-fatal injuries, which, as I mentioned, is particularly important when we're thinking about unintentional injuries, which have such a low death rate. As I mentioned, these policies vary widely. We started to see a difference here among types of laws, so it's really important for us to work to understand what the characteristics are of the policies that really make a difference. And it's not just the way the law is written, but you have to imagine that for a law like this to have an impact, people need to have some awareness of the cost the law would add for them, or that the law is part of changing a culture in a particular place. So there's more to know about the mechanisms on that end as well. So with that, I will say thank you, and I look forward to your questions and talking more at the end. Thanks so much.
All right, thank you all for joining us. My name is Michele Grim. Like I said, April said, I'm a recent graduate from Northeastern in the Doctor of Law and Policy program, and I am presenting on my doctoral thesis on a policy analysis of the Illinois Firearms Restraining Order Act, a multiple streams approach to extreme risk protection orders. Next slide. So here is a quick outline of what I'm going to be going over today. Next slide. Okay. On February 14th, 2018, Nicholas Cruz killed 17 students and teachers at Marjorie Stoneman Douglas High School in Parkland, Florida. Despite having previous FBI surveillance and complaints about erratic behavior and threats of shooting up the school the previous year, Cruz had easy access to firearms. As a response to Parkland and other mass shootings across the country, over a dozen states passed extreme risk protection orders, or ERPOs. ERPOs temporarily remove firearms from those who may be at risk from harming others, themselves or others. These laws vary by state, but generally they allow law enforcement and other family members to file petitions to temporarily remove these firearms. One such law is the Illinois Firearms Restraining Order Act, or the FRO, which was the subject of my doctoral thesis. The FRO allows both law enforcement and family members to file petitions. I chose the Illinois FRO because it was passed during the 2018 wave, and it's where I live, so I thought it was a good subject for my doctoral research. Next slide. Okay, so there were two key research questions that I answered in my research, and that is what are the key factors associated with the passage and implementation of the FRO, and how do key informants view the politics, policies, and problems in the passage and implementation of the FRO? Next slide. So the research design I used was a qualitative instrumental case study, which means that the study can be applied to other ERPOs, which I was hoping to do with the research. So the policy recommendations and the further research can be applied to other states. For the theoretical framework, I used Kingdon's multiple streams framework. So real quickly, if you're not familiar, Kingdon has a framework where there's these policy streams that are usually independent of each other until there is an opening in the policy window. So this policy window opens up with like a focused event, and these streams come together to create policy. So that's what I used for this framework. For this research, it was mostly qualitative. I interviewed 13 key informants. 4 were from Illinois gun policy advocacy groups, 3 from national gun policy advocacy groups, 2 from mental health advocacy groups, 3 government actors, and a researcher. I used snowball sampling and also publicly available witness slips from the Illinois General Assembly website. Next slide. We can skip this one. Next slide. All right. And then real quickly, my analysis process was I transcribed the interviews. There was a 2-step coding process. And then I confirmed the findings with the debate transcripts that were on the General Assembly website. Those were also publicly available. Next slide. Okay. So the findings from my research, I found 4 themes within the when I interviewed the key informants. The first theme is while mass shootings were the catalyst for FRO passage, the FRO is perceived as a tool for suicide and domestic violence prevention. And the majority saw mass shootings as the primary driver for FRO passage, especially Parkland. A lot of the key informants felt that Parkland was really a driver for this law. Given that, a lot of the key informants mainly saw this as a tool for suicide and domestic violence prevention. So, the second theme was stakeholder education and training. There were 2 sub-themes with that. So the first one is education for the public. And key informants noted that the public did not know about the law. So there needed to be some like public service announcements from lawmakers or the public health department about the law, or an awareness campaign for the law. The second sub-theme is education and training for criminal justice staff, and 3 criminal justice staff, so law enforcement judges and circuit clerks. Those were the 3 that key informants mentioned, and mainly law enforcement. So a big theme was that law enforcement's role is going to be really critical in implementing the FRO, because while these laws allow family members, key informants noted that many may not feel comfortable going to the judge and petitioning for their family member, so they can go to law enforcement to petition that for them. The third theme is bipartisan support. So in Illinois, I'm in Chicago, which is more of on the liberal side, and then you have the rest of Illinois, which is kind of the downstate. There's a lot of conservative areas. And what was really important with this bill is that there was some downstate support from those conservative legislators. And a lot of that had to do with the Illinois State Rifle Association coming to the negotiating table and helping negotiate the bill, rather than saying we don't approve of this. But there were some negotiations with Chicago and Collier County legislators with the downstates. That was really helpful in getting this bill passed. The last theme is Second Amendment sanctuary counties are perceived as a barrier to FRO implementation. And for those who don't know what a Second Amendment sanctuary county is, they have declared these counties as sanctuaries for the Second Amendment. So they feel like they're immune to upholding state laws that interfere with the constitutional right to bear arms. So the key informants noted that these counties are putting their constituents' lives in danger. And some of the key informants attributed this to the urban and rural divide, again, of Chicago and the downstate conservative counties, and also the gun culture and gun rights groups' influence in the downstate counties. Next slide. We could skip this one. Okay, so I had several recommendations for future study. One of those is research from the same cohort, so the same cohort from the 2018 wave. While the framework was the instrumental case study, I do think that there should be some research from the same cohort, because it would be really interesting to compare and contrast those experiences with those laws. Another recommendation for future study is law enforcement's role in extreme risk protection orders. The key informants in my study felt that it was really important to know that law enforcement had a critical role and that law enforcement understands their role in ERPOs and the FRO. And then the last one is that we do need more study around Second Amendment sanctuary counties, because we really don't know the scope of their reach. And it would be really interesting to see if they do have some kind of influence on the on these laws. Next slide. And then I had a few recommendations for policy. So one of those was adopt ongoing statewide training and education on ERPOs, secure funds for education and training, create clear policies for law enforcement, and then hold sanctuaries accountable for refusal to follow the law. Next slide. Thank you.
Hello, everyone. As Dr. Zeoli mentioned, my name is Jennifer Paruk, and I am a doctoral student at Michigan State University in the School of Criminal Justice. Dr. Grim was just speaking about ERPOs in Illinois, and I will be presenting about ERPO respondents in Florida. Next slide. So before we get started, I'd like to note that this study was funded by the NIH, and our findings in this presentation today do not necessarily represent the official position of the NIH. Next slide, please. Also, thank you to the FACTS Consortium, and a big thank you to all of our coders, some of whom are listening to this presentation. The coding these ERPO cases could sometimes be very emotionally difficult, and we're grateful for their work. Next slide, please. So as Dr. Grim previously mentioned, extreme risk protection orders, or ERPOs, are civil court orders that prohibit the respondent from purchasing or possessing a firearm or ammunition for a certain amount of time. These ERPOs are for individuals who are determined to be at significant risk of harming themselves or someone else in the near future. Currently, 19 states and the District of Columbia, the areas in green, have passed ERPO laws, with the majority of these states having passed them since 2016. In Florida, the state we're focusing on today, the legislature in 2018 passed the Marjorie Stoneman Douglas High School Public Safety Act in response to the Parkland school shooting. ERPOs were part of this new legislation. Next slide, please. So in Florida, only law enforcement officers or agencies are allowed to petition for an ERPO. After they submit a petition for the risk protective order, the court will hold a final hearing within 14 days. At the hearing, the petitioner needs to show that there is clear and convincing evidence that the respondent poses a significant danger of causing personal injury to themselves or to someone else by having a firearm or ammunition. So if the risk protective order is granted, the respondent is required to surrender their firearms, ammunition, and concealed carry permit to local law enforcement, and this prohibition can last up to 12 months. The court can also schedule a compliance hearing within 3 days of the order being granted, in which the respondent needs to prove that they have indeed surrendered their firearms and ammunition. As part of the final order, the court can also order a mental health or chemical dependency evaluation, and the respondent is allowed to request one hearing to vacate this order. Next slide, please. Petitioners can also optionally request an ex parte temporary hearing. This ex parte hearing is held either the same day the petition is submitted or the next business day without notice to the respondent. The burden of proof for this order is lower. Instead of clear and convincing evidence, petitioners need to show reasonable evidence that the respondent poses a significant danger of causing personal injury to themselves or someone else in the near future. If this ex parte order is granted, the respondent is required to surrender their firearms and attend a compliance hearing similar to the final order process. And this ex parte firearm prohibition lasts up until the final order hearing. Next slide, please. So the Florida ERPO statute allows the court to consider several respondent behaviors, such as a respondent recently engaging in an act or threat of violence against themselves or others, or unlawfully or recklessly using a firearm. So as you can see here, the petition typically has a list of checkboxes that law enforcement can check. A petition must be accompanied by an affidavit made under oath stating the specific statements, actions, or facts that give rise to a fear of significant dangerous acts by the respondent. Next slide, please. Due to the newness of the Florida ERPO law, we lack research on the circumstances under which ERPO petitions are filed and on the ERPO respondents themselves. Therefore, we want to know how are petitions being used in Florida, what respondent behaviors led to the petitions, and what proportion of temporary and final petitions are denied. Next slide, please. To conduct this study, we collected all ERPO cases from Florida counties from March 2018 through May of 2019, the first 15 months of law enactment, and trained research assistants double-coded each petition for respondent demographics and behaviors, and discrepancies were addressed. So we started coding and cleaning alphabetically by county, and some counties have more petitions than others. Therefore, coding is still in progress, and today we're presenting 385 cases from 20 counties. It's important to note that some of the cases did not come with the law enforcement affidavits or other supporting information. Therefore, we'll be presenting demographics and case outcomes for all cases, and then respondent behaviors for just the 315 cases that had the affidavits and supporting information. Next slide, please. So on average, respondents were 40 years old, and respondents' age ranged from 13 years to 94 years old, and 10 of the respondents were minors. A large majority, 90% of the respondents were male, and 69% of the respondents were white. Next slide, please. 69% of the respondents had a gun at the time of the petition, and 51% of all respondents had unlawfully or recklessly used, displayed, or brandished a deadly weapon. Next slide. So for example, one of the cases noted that the day before the petition was filed, the respondent texted his wife a picture which showed the barrel of his AR-15 rifle inside his mouth. Next slide, please. 78% of the respondents had histories of using or threatening physical force, violence, or harm against another person. 53% of the respondents had histories of suicide threats, attempts, or ideation, and 35.6% of respondents had histories of both interpersonal violence and suicidality. Next slide, please. 46% of cases included descriptions of the respondent's substance or alcohol use or misuse, and 57% of the respondents were subject to the proceedings of the Baker or Marchman Act. The Baker and Marchman Act in Florida allow for the involuntary mental health or substance use examination of individuals who are in danger of harming themselves or someone else. So next slide, please. So for example, in one ERPO case, the respondent was an Army veteran who had served in Iraq and suffered from PTSD. In one incident, police found the respondent crawling in a parking lot and pretending to have a rifle in his hands. The respondent told the police he was special forces and knew how to kill people. The respondent ran into the street yelling, "I will kill people tonight." The respondent insisted that it was 2009 and that he was in the desert. The respondent was taken into custody and transported to the hospital under a Baker Act. Next slide, please. 16.8% of cases documented a safety risk to minors, and 8.3% of cases documented a risk to schools or educational institutions or facilities. Next slide, please. So for example, in one case, 2 days before the petition, the respondent left his firearm loaded and unsecured on his bed. And there was a 7-year-old child temporarily living in the residence. Next slide, please. In another case, the respondent told students at his high school that if I don't kill myself, I'm going to kill someone else. The respondent, the high school student, also told coworkers about his intentions to bring a rifle to school. Next slide, please. To examine case outcomes, Temporary orders were requested in 370 cases, so 96% of the cases. Of those 370 temporary order requests, only 2 petitions, 0.5%, were denied. A large majority, as you can see, 95.7%, were granted. Next slide, please. And before the final order hearing, 14 of the petitions were dismissed, almost all voluntarily by the petitioner. Therefore, there were 371 final order hearings. Again, just a small percentage, 5.1%, were denied, and 89.5% were granted. Next slide, please. So through our coding and analyses, we found that ERPOs are, yes, being used to prohibit firearm access for those who are at risk of harming themselves or someone else. There's no indication that nuisance petitions are being filed on any wild scale. And from respondents who threaten and use violence against youth to respondents who recklessly use firearms around children, we also saw that ERPOs are being used to protect minors in educational institutions. As we continue our coding and analysis in Florida, we'll be able to compare the Florida respondent demographics and behaviors to ERPO respondents in other states. So for example, in Florida, 35.6% of the respondents had histories of both interpersonal violence and suicidality. In Oregon, where family and household members are also allowed to file an ERPO petition, 53% of the respondents had histories of both interpersonal violence and suicidality. So as we continue this Florida ERPO work, we'll be able to learn more about the respondents who are at risk of harming themselves and others, and hypothesize how these ERPO laws can prevent gun violence. Next slide, please. Thank you.
Okay. Thank you so much for all of your presentations. And thank you, Sonia, for advancing those slides every couple seconds. We do have time for a few questions. And our first question is for Dr. Kaufman. What are some of the potential unintended consequences of cap laws?
So I'm going to think first about some of the potentially positive unintended consequences, which is that cap laws by their name are focused on children, right? But I think they're best conceptualized as a way of promoting secure storage for firearms, and that can certainly potentially benefit people who are not children. As we've heard in these presentations and elsewhere, adults at risk of unintentional injury, adults at risk of suicide, potentially other family and community members at risk of assault or homicide. So those are some of the positive unintended consequences for sure. I am interested in firearm regulations, but I think it's important to think of any law that we're talking about that has criminal liability associated with it in the context of the inequities within our justice system. And so an unintended consequence that's not so positive is that almost any law we pass, we can be pretty sure is going to be applied unequally. And we've seen that with gun laws as well. You know, not much is known, at least certainly by me and by any literature I could find, about how cap laws are actually used in prosecutions. Our suspicion is that they're maybe tacked on to other charges more as an enhancement, and that can certainly perpetuate inequity and ongoing cycles of violence, which is not what we want.
Great, thank you so much. Our next question is for Dr. Grim. What was the most surprising finding of your research?
I think there were a couple. I think one of them was the role of law enforcement, especially since these laws were designed, especially in Illinois and others, they were designed for allowing family members to file petitions. But a lot of the key informants were like, law enforcement is going to be the majority of those who will file the petition because a lot of people don't feel comfortable. And the second one was the potential impact that the Second Amendment sanctuary counties may have on these laws. I was aware of them when I was doing this research, but a lot of the key informants brought it up organically. I didn't ask any specific questions on them. So it's definitely a concern that people have, and especially since there's a lot of backlash in Colorado and other states with these laws. So those were really interesting findings that I found.
Yeah, absolutely. I'm getting a couple questions, so I'm just gonna kind of go around so everybody, has some questions. So, Ms. Paruk, you mentioned an example in which the respondent had threatened suicide the day before the petition was filed. Did you find in general that there was some kind of recent event within, a short time frame that motivated law enforcement to petition for ERPOs?
Yes, we saw that over and over, that there were often times an event that happened right before the petition was filed, but then looking back, there was a lot of other respondent behaviors that had occurred in the past that had led up to this precipitating occasion.
Back to Dr. Kaufman. Do you have any information about whether CAP laws decrease injuries due to firearms, not just deaths? And can you explain again what a non-storage based law is?
No, I don't. I wish I did have information about injuries. Like I said, non-fatal injuries are important on so many levels and are much more common. So to the extent we're able to incorporate them, it not only increases our meaning, but also our sort of mathematical power, right? And I apologize for the confusingness of the definition. So storage-based laws apply when a firearm could reasonably be accessed by a child, whether or not any child actually does anything with that firearm. The sort of more lenient laws apply only when a child gets a gun and does something with it. Thank you.
Thank you. And so Dr. Grim, I assume you knew you were next. So it was interesting that the firearm restraining order was seen as a tool for addressing domestic violence.
Yes.
Illinois has a law that allows firearm restrictions on domestic violence restraining orders and relinquishment of those firearms.
Mm-hmm.
What sense did you get about why this law was seen as a domestic violence tool? Did you see it as people thinking they would work in concert with the domestic violence restraining order firearm restrictions, or what?
So a couple of the folks that brought it up noted that the domestic violence firearm law is a little limited. And actually with the domestic violence community was against it. And then I think they went neutral. I have to look that up again. But they, yes. So they're hoping that it would fill that gap that the domestic violence gun restraining order law would fill those holes that that has. So yes, hopefully working in concert with that. And yeah, no, that was another interesting finding that I found, that a lot of the key informants did mention domestic violence since there is a law here. But yeah, hopefully working together with those two laws to kind of fill that gap that the domestic violence one has.
Okay, thank you. And Ms. Paruk, are you aware of states whose laws allow petitions to be filed by anyone other than family or law enforcement? And I can take this one if you want me to.
Yeah, I know that there are several states, and if you want to, yeah, that would be great.
So Maryland allows mental health practitioners. I don't know if Shannon Frederoli is on here somewhere. If Maryland allows any type of health care worker. But it definitely allows mental health care workers. And California is expanding the list of people they are allowing to petition beyond family and law enforcement to include, I believe, teachers and possibly co-workers, but I would have to check on that. Not many states are, going that route at this point. And some states, like Florida, limit it to just law enforcement, don't even allow family members to apply for them. Are there any more questions? Oh, there's one last one for Dr. Kaufman. How do you think we could make CAP laws more effective?
Well, I think the first piece of that we can see a little bit in our preliminary results, that if you wait to apply the law until a child has been injured or injured someone else, it's probably not going to be as effective. So I think that these laws can go along well with other secure storage efforts. I also think telling people to do something in a law that they may or may not know about, telling people to do something without giving them the physical equipment to do it is probably less helpful. So I think marrying these laws to some of the other excellent secure storage promotion activities that we're going to hear about throughout the day, would be ideal. I'm also working clinically. I apologize about that. So I think pinning this along with other interventions will enhance both.
Great, thank you very much. We got one more question for Ms. Paruk. Can extreme risk protection orders be used in situations? I'm going to answer this one. Can extreme risk protection orders be used in a situation where there is a gun in the home owned by a parent, but in the home is a homicidal or suicidal adolescent, for example, who doesn't own a gun? And the answer, in short, is it depends. It depends on the state and possibly on the county. I know that in Florida, where we're doing this ERPO study that Ms. Paruk presented, that there are cases where a dangerous adolescent, an adolescent who is judged to be an immediate or imminent or clear risk to themselves or others, results in the parents being disallowed from having a gun in their home, temporarily, of course. And I know that's happened in Broward County, but I don't know about elsewhere. But this is one of the questions that is definitely in need of not only research, but I think states and counties need to really grapple with this question themselves and figure out what they're going to do. We know that sometimes adolescents are suicidal. Sometimes they're a risk of danger to themselves or others. And if, the parent keeps a gun and it's out, they can access it somehow, then that might put other lives at risk. Much like the example that Ms. Paruk presented, where somebody had an extreme risk protection order filed against them and granted because they left a loaded gun out in a home where they had, was it a 2-year-old? A young child, maybe 7-year-old, I can't remember, living there. And the child could access it. That wasn't necessarily about the parent or the gun owner being homicidal or suicidal themselves, but it was about them engaging in this risky situation where the child could have accessed the gun and been harmed or harmed someone else.
It's the perfect marriage of both policies.
Yeah. Okay, any more questions? Oh, you're welcome. The person just wrote, thank you. So any other questions? No? Okay, well, thanks for joining us.